Hey everybody, it's John Schumacher here with Health Jams, and today we're chatting about online marketing, social media, and HIPAA. So if you're a healthcare provider who has any questions at all about HIPAA regulations, licensure, other regulations in the healthcare industry, and you're using online tactics, online marketing, or social media to post about information in your area, this will be a great conversation for you today. So today I'm joined by my co-host, Michael Bloom, as always. Michael, why don't you just say a quick hi? Go ahead.
Hello, everybody. Good evening. It's so great to have you here. I'm so excited for this edition of Health Gems. This is such a great topic that I'm looking forward to learning along with you. Just want to let you know for housekeeping, there is a chat box for those of you attending live. Feel free to type your questions and comments along the way. I'm going to be keeping track of the chat as well as participating in the live discussion. And we will be talking probably for about 30 minutes, the group of us here, and then we will get right into your questions. So we definitely want to hear from you. This is our casual interactive forum, and we're so glad to have you, and I can't wait for John to introduce our guest.
Perfect. Thank you, Michael. And Michael will be hopping in during some of the conversations, some of the questions here today. And yes, our guest, we are fortunate to have David Harlow, who is a healthcare attorney with over 25 years of experience in the healthcare industry. He's got an extensive background. He's a thought leader, a blogger in the industry. So he's got a lot of knowledge on regulations, on law when it comes to online tactics in the healthcare industry. So, David, thanks for coming on, man. What we'll do is just have you just start off by, or let me just give a quick disclaimer before I introduce you here. Almost forgot that this is just general information. So please, if you have a specific query or a specific incident, please consult with your own attorney or consider hiring David's firm, as David's done a lot of work in this industry with both individuals and healthcare businesses. So now that that's out of the way, David, let's bring you on. Just start off by sharing a little bit about you, your personal background, and then we'll jump into the questions.
Thank you very much for having me on. I am, as you said, a healthcare lawyer and consultant, and I have worked with healthcare providers one way or another for about 25 years. I started my legal career as a real estate lawyer, and I like to say that's helpful in my background because most healthcare is provided indoors. Although recently what I've found is that more and more healthcare is being provided online. And as that tectonic shift has been taking place in the industry, I've really undertaken a shift in my practice, and I'm working a lot more with folks in the online space, and fewer of the folks I work with are building new hospital wings these days. The effort is really in building out the online space, the electronic tools, the patient engagement in ways other than bricks and mortar.
Right, absolutely. Yeah, there seems to be a huge shift towards even hospital systems, I believe, using social media. I've heard of a couple companies or a couple hospitals. Was it the Mayo Clinic, David, who was doing that, or somebody who they were actually building specific social media groups to engage patients?
Yes, that's right. As a matter of fact, I'm on the external advisory board for the Mayo Clinic Center for Social Media, and they are really leaders in this area. Lee Acey and his team have really taken a step way out in front to deliver information in a useful way to people where they are, which is really what you need to do in any industry. And healthcare is a little late to the table, particularly because of concerns about private information being broadcast in public settings.
Right. And are you seeing like trends in addition to larger hospitals, but individuals, practitioners, small businesses, are they using these tools? Are you helping these people, and are you seeing an increase in their usage of these tools as well?
Oh, absolutely. It's not just the large academic medical centers. I mean, a place like Mayo can have an event where a surgeon who's, the only one in the country who does a certain kind of a surgery can be on the spot and available to connect with people via Twitter for a 1-hour tweet chat, for example. But the same tools, since there's such a democratization of the technology these days, the same tools can be used by a small physician practice in a suburban location that is focusing on pediatrics, let's say, Or I know a pediatrician in a relatively small practice who's done a series of videos posted on YouTube about when new parents should not bother to bring their kids into the office.
I love
You know,
that.
not that he doesn't want to see them, but at a certain point, bringing a baby in, you're exposing the baby to more infection
Yeah.
unnecessarily, and really, it's the nervousness of a new parent, and you can address that in other more effective ways. So the tools that we have at our disposal today are just tremendous, and the issue is learning how to use them appropriately at either end of the spectrum in terms of size and sophistication of practice, and everywhere in between.
Right. Yeah, and that's the argument for telemedicine, right? And using technology is people, don't have to come in for, oh, I have a little bit of a headache. What do? I go to see the doctor. Or, you can consult with people, remotely more, which is just going to be a huge cost-saving factor for the healthcare industry and as well, right? I mean, there's just too many visits happening that aren't needed,
That aren't needed, and that can be more appropriately, triaged and dealt with in a remote setting, remote context. Even Medicare has announced last week. Rule will be officially published as a draft rule tomorrow. That they're going to pay for more physician services provided through telehealth.
There you go. Awesome. So, what are some of the key issues that we face as healthcare providers when it comes to online tools, social media use in any setting, whether large or small, that we have to think about to keep us on the right side of the law?
Sure. Well, the key issue that comes to mind first is privacy. So many of the social media platforms that we're talking about are in fact public platforms. Some of them have some private features that you can opt into. You can set up a private group on Facebook. You can set up a private chat. You can send a direct message on Twitter. But the question is, how private is private? Is it really private? Is it private enough to pass the test of being compliant with HIPAA? And that's everybody's bugbear, is HIPAA. I can't do it because of HIPAA. I can't do this because of HIPAA. I can't do that because of HIPAA. Basically, I've found that in every few years or so, there's another healthcare law or regulation that comes along, and people who don't want to do things blame the new law and say, I can't do it. This year it's because of HIPAA. 10, 15 years ago it was because of anti-kickback laws, fraud and abuse. Can't do it, can't possibly do it. When in fact, with a little work, a little digging, you can often get, I have found, at least 90% of the way there. You may not be able to do exactly what you set out to do, but you can do something pretty darn close, almost always. And that, I think, is a lesson that people need to hear loud and clear. That it's possible to work within the guidelines. So in the HIPAA context, what does this mean? So even if I wanted to use an open communication platform or something that wasn't 100% secure or private, the bottom line is that the HIPAA rules exist for the protection of patients. So if a patient consents to a conversation in a non-100% private, 100% secure setting, it's up to the patient.
Okay.
So the patient can basically waive that. If you go to a new doctor, you're handed a 10-page form that you're supposed to sign a receipt for, a notice of privacy practices, and one of the things that those forms don't say is, dear patient, is it okay with you if I text you? Is it okay with you if I tweet you? Is it okay with you if I communicate with you in ways that are not traditional for healthcare providers? And the laws and the regulation permit that, but general practice in the healthcare community just don't.
They don't. Okay. So, I mean, as far as, let's just go through a couple things. A couple things pop to my mind, and this may be a bad question, but I'm going to go ahead and ask it. Is Twitter okay with consent? Is Facebook okay with consent? Is LinkedIn, communications, all of these Are there any that aren't okay? Are they all okay as long as the patient gets consent? And how do you get consent over Twitter when the thing flies down the page, you know?
Right. So, I mean, the question also becomes, does it really make sense to be delivering healthcare services via Twitter? Probably not.
No.
You probably want to take the conversation offline or into some longer form setting or into, for example, a private Facebook group. There are a number of private Facebook groups that organizations have set up for conversation. It could be, with a large group. We could be talking about 100 people, 200 people. But just as some people are comfortable with group appointments with their primary care physician or specialist, or for example, a cardiologist who can have a group appointment. So rather than pumping people through 10, 12 minutes at a time, you can have an hour, hour and a half long conversation. If I have a question that I want to ask my cardiologist, chances are every other person of my age and profile who has an appointment coming up with a cardiologist wants to ask the same question. So why push the cardiologist through 5 appointments where he can't answer the question? Let's all get in the same room together and answer it. So again, you can put that experience online. So you can have the equivalent of a group appointment online, and with consent, it's okay to do. It just doesn't need to be public.
So how do you get consent? I mean, how do you just have them click like I consent as they click in and have it secured and then go into the Facebook group? And you can actually use Facebook groups in that way, huh?
You could, yes.
Okay. So how do they consent?
Yeah, by agreeing, by joining the group as a Facebook group administrator. I imagine you can set up a page or a tab of terms and conditions that would lay that out. And you basically identify the fact that, hey, it's the internet. It's not 1,000% secure. It's pretty darn secure, but you're willing to do this in order to get the benefit. And folks who are active in social media who have significant healthcare needs are generally willing to give up a little bit of privacy in order to get better care, in order to deliver better possibilities in terms of research and development to others. 6 months or so ago, there were a couple of surveys that showed almost 100% of people who were really active in social media were totally fine sharing their private health information for research purposes, even though 2/3 of them acknowledged that they would probably have repercussions in the areas of employment and insurance and other things. Because even though that's illegal, I mean, we have rules against that, but there's certainly pretexts that people pull and say, well, sorry, you're no longer insurable, or we can't hire you, or whatever, and they'll give an excuse. But so at some point in the future, maybe we'll get beyond that. I don't know.
Okay. So basically, to boil all of that down into like a takeaway message for everybody listening to this today, it's okay to use social media groups if you want to gather up a group of people to your cause. That's okay as long as they consent to doing that.
That's right. Now, many platforms are now creating more secure settings. So, for example, one of the telehealth areas that is now going to be reimbursable by Medicare is our psych services. So you can have a Skype or other, maybe a little more secure than Skype. I don't know the security issues around Skype in particular, but you could have a secure video chat with a psychotherapist, and that would be reimbursable by Medicare.
Right. And I was just going to ask that actually about video conferencing, because I know a lot of people would like to see clients remotely, but you can't see them across state lines. That's just want to make that point, right? Like you can't do telemedicine unless you have a license in the other states.
Right. Good point. That's a very much a live issue now with the Federation of State Medical Boards. The AMA has weighed in on this issue, and there may be some movement in the future to make it easier for someone licensed, say in Massachusetts, to see a patient remotely in New York. But right now, you really need to get 2 licenses. So there are people who have, I mean, I know people who have 25 different medical licenses in different states so that they can provide services through telemedicine tools to folks in all those different states.
Right, right. Yeah. Do you see that changing? Do you see it's heading that way, or is there too much at state for each state to keep their licensures separate?
Right. There's a lot of, you know, in any sort of professional licensure and credentialing setting, there's always the danger of the medieval guild mentality creeping in and sort of protectionism. But I think we're getting to the point where folks will recognize at the state medical board of registration level that if you're licensed in Massachusetts, you're probably okay enough to be licensed in New York, and they'll incorporate some sort of reciprocity.
Okay, right, right. As far as actual name dropping some video platforms, I don't know about Skype. I don't know if they're HIPAA compliant. I know a service called VC. I don't know if you've heard of that one, David.
Yes.
It allows HIPAA compliant video conferencing, and then I think Google Helpouts has a setting for that. I was just talking to a gal the other day about that, and
Right.
I think, and you could correct me if I'm wrong here, that you're allowed to use Google Helpouts, which is a little different than Hangout, with same platform but a different style or setup, I guess you could say, to conference with people, and it's considered HIPAA compliant. Is that correct?
I'm not positive about the Google Helpouts, but VC and there are other platforms, there are other telehealth platforms that can be used, and some that are white labeled to healthcare provider organizations.
Okay.
John, could you spell out that video service?
Oh, God. Let me open another browser and look real quick here.
Okay, we don't have to do it right this second, but it'd be good for people to know.
VC, I think, is what it was called.
We can always drop it on the replay page. So
I think it's VSEE, I believe.
VSEE? Yeah, I think you're right, David. I think you're right. Yeah, let me see here. Let me confirm that real quick.
Yeah. But the point is that there are rules, and the rules are there to protect patients. And sometimes we forget that they're there to protect patients and not to just create barriers.
Right.
That's not to say that everything in the universe is waivable by a patient, but there are things that may be waived by a patient. And there's, you know, a certain amount of common sense needs to go into this. As we said before, there's certain messages that you might not want to send out on Twitter. There was an example in Boston a couple of years back. There was a city councilor who heard shots fired while he was in a neighborhood at a neighborhood meeting, and his cell phone was about to die, and he decided he didn't have enough juice in his phone to call 911. So instead, he tweeted the fact that he heard shots fired at such and such a location, and he was sort of relying on the fact that he thought he had enough engaged followers that somebody else would pick up the phone and dial 911.
Right. And he got in trouble for that.
Yeah, that's not a really good idea.
Yeah, yeah.
I mean, that's not a sharing of private information, but it's a sharing of information. It's using the tool in the wrong way. So I guess is my point. There are tools that are good for certain things and just not good for other things. And if you're dying to use Twitter all the time, you think everything is tweetable. That's not necessarily the case. I think you need to be flexible and use the right tool for the job. Just as you would in using these tools for marketing and other sorts of engagement purposes, certain tools are better at doing certain things. And you always want to keep that in mind.
All right. All right. Should we move on to the next question, Michael?
Sure. I just want to say first, I'm really excited to hear about the changes in Medicare for making telemedicine more accessible, because I know as somebody who supports a lot of caregivers who are caring for elderly loved ones, even taking some elderly folks to medical appointments can be a drag on in terms of, you know, just an inconvenience distance, people have frailty. So if there's the ability to be able to communicate with the medical team without always having to travel in physically to an appointment, I just think this opens up such a wonderful, wonderful service to better care for folks. And even in
Yeah.
the mental health arena, the same thing. A lot of people miss psychiatric appointments. I used to serve people with disabilities for many years, and I know people wouldn't just go to their appointments. So often, if they were able to do it right from the comfort of their home without travel, appointment completion would probably go up.
Right.
So,
Yes.
Yep.
which is great. So anyway, I was just wondering, just because I know we're talking about HIPAA, and I think it's great to think about all the flexibility that we can have based on making it easier for patients, and that patients can, or clients that we have, can give permission. I'm just wondering if there's any other sort of laws or regulations, either within HIPAA or from outside of HIPAA, that as healthcare professionals we should be thinking about.
Sure. So there are other rules, and there are also other agencies who enforce rules, including a little bit of a turf battle going on these days between Health and Human Services and the Federal Trade Commission in terms of enforcing HIPAA. And some folks in the healthcare arena have gotten slapped down by the Federal Trade Commission, which is, you might be surprised to hear, as opposed to Health and Human Services for HIPAA violations, privacy violations. So that's something to be aware of and concerned about. There are also other rules. There are other kinds of records and services that don't rise to the level of being covered by HIPAA. In this day and age, we have a lot of people using personal trackers of one sort or another that are connected to the internet, or that can be from which data may be uploaded to other repositories and so forth and so on. And those repositories of data that's gathered, let's say from your Fitbit or something like that, people think of that generically as sort of health-related data and might think that that's covered by HIPAA, but it's not. HIPAA covers health information that is going into or out of an electronic health record maintained for a patient by a healthcare provider or a health insurance company.
Okay.
So there's a lot of other stuff flying around that's out there. It's not covered by HIPAA. Doesn't mean that it's not covered by anything. There are breach notification rules that cover that kind of data that are enforced by other agencies, Federal Trade Commission again. There are state laws that differ from state to state. There are state laws that cover different kinds of data. If it's quote-unquote sensitive data, which means different things in different states, it could be subject to a whole host of other state-related rules and regulations, even if it's not subject to HIPAA at all. Any personal data of certain kinds is subject to privacy rules, even beyond healthcare data, financial data, other information. And we keep hearing about all this data being lost or breached. And so it's important for folks getting involved in this one way or another to be aware of the whole variety of rules that are out there.
Okay. All right. So a lot of our listeners are the solo practitioner, the small business person. Just give us like one takeaway that they should look out for, and then we'll move on to maybe a couple case studies.
Well, the real issue is to think about what information are you sharing, what platform are you sharing it on, and think about the coffee shop rule. If you wouldn't talk about it in a loud voice in a coffee shop, you probably shouldn't be posting it on an open forum online.
Okay. All right. So let's go through a case study. Let's just give a couple of examples before we get to the Q&A part of the webinar here. And let me just throw this out here. So let's just call somebody Bill. Let's say Bill is a physical therapist, and he's not sharing potentially patient-related content, but it's simply building, let's say, an information product where he helps other physical therapists with a task or a business situation. Are there any, if that makes sense, but are there any rules or regulations regarding HIPAA or regarding privacy that he would even need to worry about if he's not using any other data from a client or patient in that case?
Well, in this example, we're not talking about patient data at all.
Right.
The situation may implicate other kinds of issues, like licensure issues, like is this person training folks in the same state where he's licensed to practice? Is he training people in other states? Does he have to be providing that information only if he's licensed in another state?
Right.
Certainly would if this were sort of a continuing education thing where somebody has to get continuing education credits in order to satisfy a licensure requirement. If it's more of a business coaching situation, then I would say it doesn't really matter if he's licensed in the other state. You're taking in information, someone who's attending his course, and will use that together with your professional knowledge that's subject to local licensure in order to build out a broader range of services in your own practice.
So for B2B businesses, like my example, where he's basically packaging his knowledge on an online medium and sharing it with another therapist, would that wouldn't have anything to do with HIPAA, but it may have something to do with licensure laws, maybe. It's hard to say. It would depend on the clinician, right, and their state and all their rules.
Well, I mean, if if you were trying to get continuing education credit for this seminar, let's say, then that would be an issue. If not, then
let it go, huh?
Good luck.
Right. Nothing really legal overall to worry about.
No, not at all.
Okay. Well, that's good to know, because I think a lot of, like myself at least, when I was a physical therapist starting off, I was creating ebooks on pain relief, right, and selling them and doing things like that, and not necessarily there's licensure issues I think you need to be aware of, which I had to look into, but not necessarily any larger national HIPAA type rules. Is that correct?
Right, because again, we're not talking about patient data,
Okay.
and HIPAA exists to protect the patient.
So even if it's, you're like, for in my case, teaching a potential patient an exercise through the internet, there's nothing with HIPAA there.
Well, that's a different situation.
Okay.
What I had understood you to be asking is a physical therapist teaching other physical therapists. If you're talking about teaching a patient, then the question is, are you providing a professional service that is subject to state licensure? And are you able to initiate the patient-provider relationship remotely?
Mm-hmm.
So in the telehealth context that we've talked about at the physician level, some states take the position that even if you're licensed as a physician in my state, you are not able to initiate a physician-patient relationship by video. You can only initiate that in person. And once you've initiated that, you can provide services remotely.
Okay.
So there's a recent case in Idaho that plays on that fact.
Okay.
And the bottom line is that the board is very protective of the profession and is not happy about seeing interlopers get involved. So in the context of providing any sort of service or therapy online or via some sort of video medium, telehealth medium, the issue is going to be, are you licensed to provide the service where the patient is located?
Right.
And have you appropriately initiated a clinician-patient relationship?
Right. And does that same thing apply, let's say, if I didn't see them via video conference, if I just simply, say, wrote a book on pain relief and sold it to them? Would that be different, correct?
Right, because you're not professing to have a one-on-one clinician-patient relationship. Now, you can have a one-on-one communication that is clearly labeled, let's say, as, this is not medical advice.
Mm-hmm.
This is not healthcare advice. We're just chatting here. just as you did so kindly for me at the top of the hour, this is not legal advice.
Right.
I'm just talking.
Yeah.
Uh,
I almost
and
forgot that.
they say free advice is worth what you paid for it. But the issue is that for a clinician to be able to deliver a professional opinion, to deliver professional services, there has to be a professional to patient relationship established. Now, just as an example, and following on in the example you're giving, I have clients who create platforms for the delivery of information that is not healthcare. Okay, so someone who is can use the platform for a clinician who's licensed only in state A to provide information to people who are living all over the country. But it's information. It's
Gotcha.
not medical services.
So it's just like for like a blogger or something like that. They're putting out their advice or their knowledge, but they're not, calling that medical advice. So basically, if you're going to see people face to face and engage in that, you need to know your state laws. You need to understand, where that is. And even with that, can you clarify it, not medical advice, and get away from your license, or does that depend on the license and the state and everything?
Well, it depends on the state, because every state interprets these things differently. But in general, it is possible to provide sort of genericized advice that is disclaimed. You're saying this is not medical advice. And the example I'm thinking of is a client that has a smartphone app that can snap a picture of a skin growth and have it zapped over to a dermatologist. Dermatologist
Right.
looks at it, not diagnosing the patient, but the dermatologist can say back, looks to me like that might be XYZ. If I were you, I would get the following over-the-counter ointment, use it. If it doesn't clear up in 2 weeks, see your doctor.
Mm-hmm.
I think it'll clear up in 2 weeks. That's very different from diagnosing a disease and prescribing a prescription medication.
Right. So there seems like there's a lot of semantics, a lot of gray area still, a little bit, within that. But let me hit you with one more example before, and I'll try to be quick.
Sure.
I know we might be going a little bit over, guys, but hey, let's let it flow.
We do have a few questions that come in.
This is good stuff. What's that, Michael?
I said we have a few questions that have come in
good.
too.
Yeah. So let's just say let's give another example, like a nurse practitioner, for example, who wants to be an advocate for somebody who is like status post a certain surgery or something, and that person has a passion for that advocacy and wants to create, a website, products, write books, do speaking engagements, and create like an online following. Is there any, I know it might be kind of vague, but is there any issues there that they need to think about? Because they are technically being an advocate for a group of people. I guess that would probably be situational depending on if they're working directly with them or not. Can you touch on that, David?
Right. Well, I think what I hear you saying is somebody who wants to have an online community and host some online information about a particular condition or set of conditions.
Right.
Is that right?
Yeah, and let's say create a membership site or create, ebooks and sell stuff online and things like that around that, build a community, those kind of things.
Right, absolutely. I don't see anything wrong with that. And again, as it happens, I have clients doing things like that as well. And the line is this: it's not, you're not providing healthcare services through this platform. You're publishing information that happens to be written by a doctor, based on the reputation of a particular doctor. People will lend that more or less weight. And there's opportunity to share information, to share experiences. Once you create this online sort of community, patients will contribute information about their own experiences. Or, I tried drug X, it's off-label use, and I had good experience with it. I don't want physicians in my community saying things about that necessarily, or maybe that's going to be okay at a certain point. But patients can certainly share their experiences, and there's big disclaimers on the website that say this is not medical advice.
And that's enough to say, even though you're a licensed professional, I'm building a website, I'm putting out information and knowledge that I have. This is disclaimer, technically not medical advice, and
Right,
that should
because
cover.
it's not directed to an individual patient
Gotcha.
based on an individual set of symptoms.
Okay. All right. I think that's pretty clear then. So basically, if you're engaging one-on-one with people, think a little differently than if you're just putting out information to larger groups. Is that kind of the breakdown of that?
That's right.
Okay. All right. All right, David. Well, hey, that was good stuff, man. I'm excited about that. That's a lot of neat information there. I've always kind of wondered about these things myself, and so I just kind of spitting them out. But let's go over, Michael. We got a few questions. It looks
We do, and I'm excited to share them.
Let's go over to that and see what we can do here.
All right. Well, a couple of them have to do with clarification from some of the great anecdotes and examples that were shared earlier. So I just want to go back for a moment from Dawn. David, this is a question from Dawn. You had told the story earlier about the guy tweeting about shots that were heard, and her question was, why wasn't tweeting it an appropriate platform, and whose privacy did he breach?
Oh, I was just using that as an example of maybe not the best choice of platform. It's not a privacy issue, although let's take it to a different situation using Twitter, where a hiker who is trapped with his foot under a rock. There's nobody around for miles. What does he do? Tweets a doctor who he knows, or sends out a general tweet. Let's say sends out a general tweet. You could have a doctor tweeting back and forth with an individual stuck in the back country but somehow still getting a cell signal, and the doctor could tweet instructions to this person on what to do because you have this emergency, right? So emergencies sort of trump HIPAA, and people sometimes forget that. I'd rather have some doctor tweeting instructions, in an extreme case, tweet instructions to somebody on how to amputate their own foot so they can get down off the mountain and not die of exposure, than be concerned about the privacy issues inherent in tweeting back and forth about something like that, right? You can always get a consent later. And sometimes people forget that, particularly in more sort of normal day-to-day emergency room situations.
Okay.
Great.
All right.
Great. That makes total sense. And we have a great question here from Jessica, that she's created an app that helps people self-monitor their eating disorder recovery. They can log their behaviors, substance use, and emotional state. The data is not connected to a server at this point. However, the user can send a PDF to their treatment professional, therapist, or nutritionist via email. Is the treatment professional in violation to HIPAA by getting this communication?
Yeah, again, as I said, the HIPAA rules exist to protect the patient, but they're sometimes held up as barriers to communication by providers. Now, there are other institutional reasons why providers want to be careful about how information is communicated to them. And as I said before, it's okay to tweet back and forth with your doctor if that's okay with you, or text back and forth, I should say, with your doctor if that's okay with you. But one reason why a doctor or an institution might not want to do that is that, well, what about continuity of care? So we're texting back and forth. So I have the whole conversation on my phone, the doctor says, but when I'm off next week on vacation, who's going to pick up the ball? How's that going to work? And depending on the institution and on the physician, they'll say, hey, we'll figure it out. We'll make it work. I have a patient who's actually communicating with me and wants to get better. That's great. Other patients don't want to talk to me. I can't get through to them. I can't make them better. And by the way, as a healthcare organization, that means they're going to cost me more money later. Um, so at a number of different levels, it really makes sense to communicate with people in the way they want to communicate. And the example that you gave is not a HIPAA violation, because a patient faxing to a physician information about him or herself that's self-generated or self-recorded, that is that's patient information being provided to the physician. Does that go straight into a medical record? Well, if it's just faxed information that doesn't fit a particular field in an EHR, no, it's not going straight into a medical record. It's going to some kind of notes file, and in the bad old days, it would just be brought in on paper and delivered or mailed in. It may be part of the electronic, it may be part of the medical record once the physician gets it, but it's treated differently because the provenance of the data is from the patient, right? So it's not a lab result from a reference laboratory. It's patient provided this information. Now, some healthcare providers are scared to death of that kind of information for some reason, but when a patient comes into their office, they're writing stuff down that is patient-generated information. Just happens to be conversation as opposed to actual data. And I think as a community, the healthcare community needs to be more willing to accept data from patients at face value.
All right.
That's great. Our next question, I'm going to kind of stay with the theme right now. This comes from Catherine. I asked my followers to share their experiences with hot flashes and night sweats. I had a few responses from women who volunteered this information. Is this a violation of any sort? This is not a private group.
Is this person a clinician?
I don't know. Catherine, if you could just type in and clarify what your role is in that area, that would be great. Just type that into the chat.
So basically, if they don't have a license, if they're not a licensed health professional, they don't have to worry about HIPAA at all, right? David?
That's correct. That's correct. But so in a friendly conversation like that, people can volunteer whatever they want. People understand, for the most part, that these things are open and public, although sometimes people seem to forget that. The other thing is, even if we're talking about a licensed professional, the setting of the conversation should clue people in to the fact that this is not a private conversation. Best case scenario would be to highlight that specifically at the beginning. If this is some kind of tweet chat, we're asking you, as always, to share some information tonight, but please remember it's a public forum.
Okay.
Gotcha. We have a few other questions that have come in here too that were here. Another one from Jessica. If a user or a patient gives a testimonial to your product via Twitter or Facebook, do you need their consent to post this on your website?
I think that it would be a good idea to ask for that consent. I think most people, having tweeted something publicly, would be flattered to be asked, but I think the better judgment would be to ask. It is tweeted publicly. It's out there in the public domain. I don't think you really need to as a legal matter. But if you're going to associate somebody's name with your product or service in a non-transitory matter, because Twitter, the things just fly by, and then people think, I'll never see that again. If it's going to be there in some permanent way, it makes sense to talk about it first.
That's great.
Right.
That's great. And Catherine did clarify that she's not a licensed professional. She creates cooling scarves. So, so really, really great. So thank you, Catherine, for sharing. And these were some great questions that have come in.
Perfect. All right. Well, I guess unless there's any other questions, I think there's a couple back there. I think we pretty much got to the main ones. So, David, thanks so much. I mean, just share with the viewers here where they can find out more about you if they're interested in getting advice from you or finding out more about where you're at.
Sure. So I practice at the Harlow Group, and I'm online at harlowgroup.net. My Twitter handle is on the screen, healthblog, BLAWG, and that is also the name of my blog, healthblog.com. And I write there about healthcare policy and law issues as they come up and as they strike my interest. And I can be reached through any of those platforms.
Sounds good. All right. And then I think, do we have one more question pop in there, Michael? Or
I think the question that just popped in was, what if it was just a first name that's used as a testimonial? Do you still need permission if you're not fully identifying the person?
You know, I mean, I think that maybe something, a broader discussion and sort of what sort of you know, credibility you get by not using a full name. But if you don't have the identity of the person who's giving the testimonial, sort of question the value of the testimonial.
Okay. All right.
I would agree with that as well. I know, just to add in here, it's something I was going to type into the chat, but something I like to do is at least get an email reply or something that I can save at records that says that this person is okay, even if they only want me to use their first name. You know, a lot of times I will just use first name, last initial, not to fully identify the person, but I at least want their permission.
Yep. Yep.
Yeah,
Okay.
that makes sense. Yeah, I think to emphasize something I've been saying all along, it's really up to the individual. People use HIPAA and other laws as reasons to not engage, and I think it's very important to be open to engagement and communication. And much of the health reform law that has been debated and talked about over the past number of years is really, at its core, it's about patient-centeredness and patient engagement. And for the first time ever, the words patient engagement and patient-centeredness are in the United States Code. And that's just phenomenal. And that is an opportunity for all of us involved in healthcare one way or another to use every tool at our disposal to engage patients in their healthcare. And it's certainly a lot easier to do with the tools at our disposal, and just got to do it right.
All right. Okay. All right, everybody. Well, thank you so much, David, for sharing that today and coming on our show and chatting about some really important issues. It's a great discussion. Thank you so much. So,
my pleasure. Thank you.
Yeah. And everybody who's on here still, we just want to let you guys know that, you know, obviously this is the online marketing forum for healthcare entrepreneurs. So Michael and I are opening up our schedules for three slots, Michael, to take a look at your business, your online website, your whole marketing process there. If you are online doing social media, doing website type work, Michael and I have been doing that for a little while now, and we have definitely spent some money and time learning that. So if you're interested in having us look at your setup, your website for free, go ahead and email me at Jon at newwavehealthcare.com. All right. Anything else, guys? I think we're Michael. You good?
It's been a fabulous discussion. I'm so pleased to meet you in person tonight, David.
Yeah.
Thank you. My pleasure, gentlemen.
All right. Good night, everybody.